12-616. For what purpose does the gentleman from Florida seek recognition?
Thank you, Madam Chairman. I have an amendment at the desk. It's number 11.
Okay. The clerk will designate the amendment.
Amendment number 11, printed in Part B of House Report number 112-616, offered by Mr. Posey of Florida.
Pursuant to House Resolution 738, the gentleman from Florida, Mr. Posey, and a member opposed will control 5 minutes. The chair recognizes the gentleman from Florida.
Thank you, Madam Chair. I'd like to yield myself as much time as I may consume.
The gentleman may proceed.
Thank you. Madam Chair, today in Washington, bureaucrats are able to craft and enforce rules that cost our economy billions of dollars while remaining aloof of the consequences of their actions. There remains a disconnect between those who write these rules in the comfort of the Beltway, generating reams of red tape, and the actions taken by the courts or Congress to delay or roll back those same rules. When a regulator has overreached, they have wrongfully robbed American citizens of their benefits, of their labor, and their means of productivity. Today, there is really no penalty for those who overreach. I believe regulators should be more prudent and measured when drafting and issuing rules and regulations. My amendment simply calls agency bureaucrats to account when they exceed their delegated authority. Section 104 of the underlying bill permits the court to award reasonable attorney fees and costs to a small business when they prevail in a suit against an agency that has exceeded their statutory regulatory authority. My amendment takes this a step further by requiring any attorney's fees and costs be paid out of the administrative budget of the particular office that's found to have exceeded that authority. I believe this will give regulators greater pause before they issue regulations and will cause them to double check to make sure they're on solid ground. When an agency overreaches, what they are fundamentally doing is denying an American citizen their right to pursue opportunity, create jobs, or otherwise enjoy the benefits of their labors. In a sense, they're basically robbing someone of their opportunity. Outside of the regulatory environment, when someone takes property that belongs to someone else, there's criminal sanctions if we catch them doing it. In the regulatory environment, however, the best that an American citizen can expect from the federal government is, "I'm sorry," and that's at best. We changed that in this bill, and with the adoption of my amendment, we change for that particular regulators, those particular regulators that exceed their authority. If adopted, this amendment will give more certainty to the regulatory process, and it will ensure regulators are more prudent when drafting regulations. We make sure that any damages aren't paid out of the agency slush fund, but rather out of the administrative budget of the offending office. That brings personal and government accountability to the regulatory process, something that's desperately needed. Now, they will have some skin in the game, so to speak. I urge my colleagues to support this good amendment, and I reserve the balance of my time.
Gentleman reserves. Who seeks time in opposition?
I do.
Gentleman is recognized for 5 minutes.
Thank you. I yield myself such time as I may consume. Madam Speaker, I strongly oppose the Posey Amendment because it makes even worse an already deeply problematic provision. Under Title I of this bill, a court is required to award attorney's fees and costs to a, quote, substantially prevailing, unquote, small business in any civil action to challenge an agency's compliance with the moratorium. That provision further states that a small business can be substantially prevailing in the meaning of the bill, even in the absence of a final judgment in its favor, quote, if the agency that took the significant regulatory action changes its position after the civil action is filed, close quote. There are two problems with this. First, it doesn't matter if the agency's change in position had absolutely nothing to do with the civil action. A court would still have to award attorney's fees to a small business that challenges an agency's compliance with the moratorium in court, even if the change in policy had nothing to do with the lawsuit. Bad as this provision already is, the Posey Amendment makes it even worse by requiring that an award of attorney's fees and costs be taken out of the defendant agency's budget. Agencies are already straining under diminishing financial and staff resources, thanks in no small part to the budget priorities of this House during this Congress. Further debilitating agencies by taking fee awards out of their budgets, even under circumstances when their change in position had nothing to do with the underlying lawsuit, further damages agencies' ability to do what Congress has tasked them with doing, namely protecting public health and safety. So in other words, what this amendment says is, if an agency has a regulation which in its judgment it must issue to protect the public health and safety, and a small business sues to stop that, and even if the small business doesn't prevail, if there is any change in the agency's position, and even if that change in position has nothing to do with the subject of the lawsuit by the small business, it must pay attorney's fees, and under this amendment, it must pay attorney's fees out of its own budget. Secondly, and that's dangerous because it'll debilitate the agencies that we task with protecting the public health and safety. Second of all, it's self-defeating, because if you're the agency and you know that if you are going to change your position anyway, you're going to have to pay the attorney's fees out of your own budget, better don't change. Fight the lawsuit. Don't give in. Fight the small business because you may win. Well, if you change your position anyway, if you compromise, if you say, you know, they don't have that great a case, but we can accommodate them by making a small change, no, then you got to pay attorney's fees out of your own budget. So don't accommodate them, don't compromise with them, don't make the change, fight them to the bitter end. That doesn't help the small business, and it certainly doesn't help the American people who need these agencies to police the marketplace and to protect the public health and safety. So it defeats its own purpose in addition to period. It's just wrong on so many levels. I reserve the balance of my time.
Gentleman reserves. Gentleman from Florida.
Inquiry how much time we have.
You have 2 minutes remaining.
I'd like to yield 1 minute to the gentleman from Arkansas.
Gentleman from Arkansas is recognized for 1 minute.
Thank you, Madam Chair. I rise in support of this amendment. If an agency improperly makes a regulation during the moratorium period, as written, the Freeze Act would allow a small business that successfully challenges the action to collect attorney's fees. The gentleman from Florida's amendment would strengthen this provision by ensuring that any attorney's fees awarded under Title I come out of the agency's budget and not from the general federal treasury through, for example, the judgment fund. If an office or agency defies the law and tries to make a regulation that should be subject to the Freeze Act, then that particular office or agency should bear the consequences of forcing a small business to go to court to vindicate its rights. For these reasons, I support the amendment.
Gentleman yields back. Gentleman from New York.
How much time do I have, ma'am?
2 minutes.
Thank you. Madam Chair, I yield myself such time as I may consume.
Gentleman's recognized.
Again, we oppose the bill to start with because we shouldn't have a moratorium on rules that are intended to protect the public health and safety that may be necessary. But second of all, this amendment is self-defeating because even if a small business sues the agency, two things. Number one, let's assume that the agency thinks that the small business's suit has some merit. Not enough to win the case, but some merit. Under this amendment, the agency cannot compromise, cannot say, you know, you're right, we'll make this change, because the moment it makes a change, then even if a minor change, then it is no longer the prevailing party. The small business, under the definition of the bill, is the prevailing party, and will get attorney's fees, and the attorney's fees come out of the budget, maybe the small budget of the agency. So rather than yielding in any way, rather than compromising with the small business, fight them. Fight them tooth and nail. That's what this amendment says to the agency. It is on its own terms silly and self-defeating, and I urge its defeat. I yield back.
The gentleman yields back. The gentleman from Florida is recognized.
Let me tell anyone who may not have ever seen a war with an agency over agency rules before, they dig in and they fight to the death anyway, whether it's coming out of their budget or not. I've seen them lose at 3 levels with a private citizen and go after them yet a 4th time because their pockets are bottomless and they hope they could break back of a citizen like that. You know, what makes this country unique is we believe we get our rights from God. We believe in inalienable human rights here. And we give rights to government. Government doesn't give us rights. We give rights to our government. And we're charged with administering the rights that were given to our government here in Congress. And we give the administration, we give the agencies rights to write rules. specific rules. We don't allow them, without our authority and beyond the scope of their authority, to abuse the citizens, to steal their productivity, the labor, the benefits that they've worked hard for. And that's what the agencies have done. We've asked them not to do it. They've reformed the Administrative Procedures Act a number of times. The agencies just don't get the message. They seem like it's their goal and their destiny to be the boss. Congress is supposed to have dominion over the bureaucrats, and this is one of the ways that we're going to enforce that dominion. We don't let the fox run the hen house.
Gentleman's time has expired. Thank you. The question is on the amendment offered by the gentleman from Florida. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the noes have it. Amendment is not agreed to.
Did you say the noes have it?
I did. I'm sorry.
I'd like to have a recorded vote.
All right. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Florida will be postponed.